Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada practice leader in employment law. Thank you for joining us today. We are here for the next half hour to discuss your employment rights. You're at the Samfiru Tumarkin employment rights question and answer period. And so we're going to try to answer as many of the questions as you have as possible in the next half hour. So if you have any questions related to your employment rights, be it termination, working conditions, job offers, anything like that, feel free to put your question in the chat. I'm going to try to get to as many of them as possible today. Don't wait till the end of the show to put in your question. Put it in now so that we have plenty of time to make sure we get you your answer. We have our first question coming in already from ACES. ACES is asking, I was let go for uttering threats. That happened maybe a month ago. Still don't have my record of employment. Do not have a chance to defend myself. I'm on ODSP and have legal problems, which didn't help. I think your question, Ace, is where is your ROE, your record of employment? I can tell you that for the last couple of years now, employers no longer give you your record of employment directly. Instead, what they do is they upload it to the Service Canada website, the Service Canada My Account. And if you want to review your record of employment, you can download it from the My Account website, and you don't need to wait until you receive your ROE from your employer to apply for employment insurance. So go ahead and apply for employment insurance right away if you want to get that. The ROE should already be on the Service Canada website if you were terminated a month ago. Usually the employer has 7 days, I think it is, to upload the ROE to the Service Canada My Account. Your other question I think that you're asking is related to, could the employer terminate you for uttering threats? So basically, a court is going to look at the whole context of what happened there, how long you've been with the employer, what kind of past prior discipline you had, the seriousness of these threats that were made, the whole context essentially to determine whether an employer was justified in terminating you. Now, I say that because I assume that if you were terminated for uttering threats, you were actually terminated for just cause, all right? And when you're terminated for just cause, you're not entitled to a severance package. But you have the right to have a judge determine whether the employer actually had just cause to terminate you. And if they didn't, then you'd be entitled to a severance package. So you're mentioning here that you had problems. You're on ODSP. You've had legal problems in the past that might inform or explain a little bit what your behavior was. These other factors might also contribute, right? How long had you been with this employer? What was the context? Did they ask you whether you uttered these threats, or was there some context? Was it in response to a threat or something else that you'd received? So all of that, we would need to have a bit more information on for me to be able to tell you whether the employer actually had just cause to terminate you or not. What I would invite you to do, Ace, is to contact us, reach out to us, and we will speak with you and let you know whether we think that the employer had just cause, and if they didn't, how much severance you might be entitled to. So feel free to reach out. You can reach out to us directly at employmentlawyer.ca. You have the website address there on the screen, employmentlawyer.ca. We have another question coming in from YouTube from Renee. Renee is asking, how long would it take an employment lawyer to win a case proving misclassification of independent contractor when the evidence is overwhelmingly in favor? Can a company choose to drag it on for years? So yes, what I can tell you, Renee, is that the vast majority, a large portion of our cases settle very quickly. And in fact, the vast majority of our cases settle at some point, right? 99% of these cases, if not more, never make it to trial because they're settled well in advance of trial. Including misclassification cases, this is an area where we're often successful in resolving prior to even starting litigation, let alone trial, which can, in the current legal system, can be a little while, frankly. If your matter is really one that's going to trial, it can take a little while. But like I said, 99%, if not more, of our cases settle well in advance of trial. So if you think that you have a case that you were misclassified, then instead of being properly classified as an employee, you were misclassified as a contractor, then reach out to us at employmentlawyer.ca. We're happy to talk with you, let you know what your rights are, and let you know that if you were, in fact, an employee, you'd be entitled to severance. And if you want to get an idea of how much severance you'd be entitled to, reach out to us. You can also use this great tool that we have, which is called the Severance Pay Calculator. You answer 4 easy questions, and we'll give you our estimate of how much severance you might be entitled to. So if you're looking to use our Severance Pay Calculator, it's free of charge, no obligation. We don't even need you to provide your name or anything like that. Visit pocketemploymentlawyer.ca. It's up there on the screen. Answer those four easy questions. It'll give you an estimate of how much severance we think you might be entitled to if you had actually been classified as an employee, as you should have been. Sorry. We have our next question coming in from Mr. Arts. Mr. Arts is asking, does an employer have any obligations to ensure night workers can return home safely after a shift? If you are assaulted on the way home, is your employer responsible? Well, I can tell you, Mr. Arts, that the employer has an obligation to do everything that's reasonably necessary to ensure worker safety at work. All right. So I'm sure there's some context to what you're asking me here that I don't necessarily have. I don't know where you work, how you get home from work, whether you're walking through a bad neighborhood or something like that. I would need those kinds of details. I can tell you generally that the employer's safety obligation, really extends to the workplace. Potentially might extend to areas where there's a work function. So, for instance, if you're having a Christmas party offsite, or if you're going for a dinner with your colleagues, that's organized by the company, health and safety obligations might extend there. Usually during commutes, I don't think the employer would have an obligation in that regard under health and safety, but I'd have to have a little bit more context about what you're talking about there. So that's under health and safety laws. Right now, I'm not seeing exactly how we could extend liability to the employer if you're assaulted on your way home from work without getting a bit more context of what your commute looks like, what your shifts, what time your shift ends, why you can't get into a vehicle or a taxi to go home, things like that. That's what I can tell you about that now. But if you want to provide more details in the chat, I'm happy to revisit this before the end of the show. We have another question coming in from Steve Wrights. Steve is asking, can an employer force you to take on more duties without any sort of pay increase? Is there a limit on how much they can put on you? Well, absolutely, Steve. I do think there is a limit on how much more duties the employer can put on you. The way I would see it, though, is how does that translate into actual more work for you? So what I mean by that is, if before you were added these duties, you were working 8 hours a day, and after you were added these duties, you can still get all your work done in 8 hours a day, I don't really see where the issue is. But in fact, what we see happen a lot is employers start piling on the work, so to the point where you have to work significantly more hours to get all the work done, without compensation. And that could be because you're on a salaried basis, for instance. So you receive, whatever, $60,000 a year, and that covers all the work that you do. So you were working 8 hours a day before, now you're working 10, 12, 13 hours a day. So no, that's not okay, right? An employer can't do that. What ends up happening is that this increase in hours that you're working can amount to a constructive dismissal. All right. So constructive dismissal happens when an employer says, well, that job that you've had with us, that job no longer exists. We have this new job for you. In this case, it's this new job with all these added duties, all these added hours. So that's your new job now. Well, for you to have to take that job, you have to consent to it. You have to say, okay, I'm okay with taking on these added duties. I'm okay with working these extra hours with no extra compensation. All right. And if you are okay with it, that's fine. But if you are not okay with it, as you don't seem to be, Steve, you say, actually, no, I was hired and I agreed to do this one job. I don't want to do this second job. So your options, employer, are two. You can either let me go from my job with the severance package, or you can allow me to keep the old job and not have these extra duties and these extra hours that I have to do. All right. And if your employer says, well, no, I'm not giving you the choice here. You have to do these extra duties. You have to work these extra hours. You can say, well, listen, I am not doing it. I'm going to quit. I'm going to say that, you've constructively dismissed me. You forced me to quit. And because you forced me to quit by changing my duties, my hours, and all of that, you are going to owe me, employer, a severance package. All right. And I can tell you it's a little bit of a tricky process if you're not all that familiar with employment law. So, Steve, I would strongly advise you, if you are considering saying, I don't want to take on these duties, I would rather quit and go after my severance. If that's an option that you're willing to consider, Steve, I think it's important you reach out to us, okay? So that you do it the right way, all right? Because what ends up happening is if you do it the wrong way, you might be found to have just simply quit. And as you know, people who quit aren't entitled to severance normally. So there's a right way and a wrong way of doing this. It's important to get some legal advice before you go down this path. And if you want to reach out to us, it's employmentlawyer.ca. You have the website on the screen. Reach out to us. An ounce of prevention is worth a pound of cure, as they say. And I think this is particularly true when you're thinking of claiming that you've been constructively dismissed. Another thing to keep in mind, Steve, is you might say, well, listen, I'm going to try it out. I'm not sure it's going to be more hours. I'm going to try it out. You can try it out. Try out the new terms of employment and see what you think. You don't have a ton of time to make up your mind, right? If you wait a year and say in a year, well, actually, this ended up being not great for me, I don't want to do this anymore, your terms of employment might have been changed by then implicitly into the new terms, and then you can no longer claim constructive dismissal. And how much time do you think you have? Well, on the low end, it's about 3 weeks, okay? On the very low end, it's about 3 weeks. So if you're starting to see that this is not going to make sense after a week or two or something like that, reach out to us quickly because you don't have a ton of time to do this. All right. We have our next question coming in from YouTube from Jacqueline. Jacqueline is asking, I am off on medical leave recovering from a stroke. Well, I'm sorry to hear that. My employer has stopped communicating with me completely after I provided all the necessary medical documentation. Should I assume they let me go? They have let me go and ask. Should I assume they have let me go and ask for severance pay? Is there anything I should be aware of before doing this? I'm not sure why you assume you've been let go, Jacqueline. Generally, more likely, you would be on a disability leave at this point. And again, if you've been listening since the start of the show, you'll know that you can actually access your record of employment on the Service Canada website, and it will show you what your situation is, what your employer at least thinks that the situation is. So on every record of employment, there's a code that's used to explain the reason for issuing the ROE, okay? And normally when you're on a disability leave, the code that will be used is code D for disability, all right? If any other code is being used, then maybe that will give you an indication that your employer has terminated you. But I wouldn't necessarily assume right away that they've terminated you they might have just placed you on a medical leave. So I'm not sure. I don't know whether you have access to long-term or short-term disability benefits through your work and whether you've applied. If you have, then basically you'd be communicating with the insurance provider. So right now I wouldn't jump the gun and say that you've been terminated, but if it turns out that you have been terminated, then that's likely some form of human rights discrimination, as well as entitling you to severance. You might also have some entitlements under human rights laws. So I would say first step is to check your Service Canada My Account website to see what the ROE says. What's the code they're using to explain why you haven't been to work in these last few weeks or months or what have you. And if it does show anything but D, then I would say reach out to us. Reach out to us and share with us that you can't seem to reach your employer, that they've issued an ROE that seems to indicate that you're terminated and you don't know what's going on here. And we'll be happy to explore this for you as well. So we're at employmentlawyer.ca. Feel free to reach out, employmentlawyer.ca, and we'll take a look at that for you once you've seen what the ROE says on the Service Canada My Account webpage. We have another question coming in from Joan Flores. Hi, I am seeking legal advice regarding a rescinded job offer that has left me in a difficult position. I recently accepted a formal job offer from an employer, signed the agreement, and resigned from my previous stable job based on this offer. However, the company has since rescinded the offer, citing issues with my residency status or work permit authorization. I currently hold an open work permit valid until November 2027. This decision was made after I had already submitted my resignation, and as a result, I am now without employment and insurance coverage. I would like to understand my legal options, including whether the company may be liable for damages due to the reliance on their offer, and if I can seek compensation for the financial and professional harm caused by this situation. I have retained the following documents that may be relevant: the signed job offer letter, email correspondence regarding the offer and subsequent rescission. I would greatly appreciate your guidance on how to proceed. Please let me know if you require any additional information or documentation to assess my case. So I'm not exactly sure what the issue is with your open work permit. If your open work permit is valid until 2027, I don't see why the employer takes issue with that. Maybe I'm missing something. But if an employer generally rescinds a job offer, there's a few grounds that you can pursue against that. So one ground is negligent misrepresentation. They've misrepresented to you that there was an offer that there was a job available for you to take. You relied on that misrepresentation. That representation turned out to be false and made negligently when they knew or ought to have known that that statement was not in fact true. And so anything that kind of flows from that loss, from that misrepresentation, any losses that flow from that misrepresentation are compensable. If, on the other hand, the employer might say, well, actually, it was a termination, we terminated you during your probation period, you have no claim against us, well, that also is problematic, because for a termination during the probation period to be valid, the employer has to have honestly and in good faith assessed you for your ability to do the job. All right. So here, since the offer was rescinded before you even started, the employer had no opportunity rather to assess whether you were going to be a good fit for the job. And so the termination was arbitrary. And so they can't rely on the probation period clause in your employment contract, and you'd be owed severance. So you have those two kind of pots. Either you can go after severance. So severance you're entitled to as soon as you sign the employment contract. You're entitled to severance unless there's something in the contract that limits that. So definitely, we'd like to speak to you about that option. And then there's also the option that your employer made an offer of employment to you, knowing that they weren't going to be able to follow through on that offer. You've suffered losses as a result because you quit your previous job. You can't go back to it now. You have to find a new job. So those losses might also be compensable as well. So we'd have to, you've mentioned you have all these documents, Joan. We'd have to look at these documents to give you a better estimate of how much you might be owed and under which pot. But definitely reach out to us, employmentlawyer.ca. We'll be happy to look into that for you and let you know how we can help. Employmentlawyer.ca. You have it there on the screen. We have another question coming in from Tina Berner. Tina is asking, can an employer let you go because they don't agree with your off-duty actions or behavior? Is this something that would justify just for cause termination? Yes, it can, Tina. So we can imagine any sorts of things. You imagine a scenario of someone who turns out to just be a despicable person online or something like that, or part of groups that are really unsavory and stuff like that. And the employer finds out about it. Can they terminate you for just cause for this off-duty conduct? Okay. They can in theory. In reality, in practice, it kind of depends. All right. There are some people who have been caught doing very serious things, potentially criminal things. And the courts have found that the employer could not justify an off-duty, terminating them for cause based on their off-duty conduct. And there are some times where it doesn't really take all that much. So a few things that I like to tell people, especially as it relates to their use of social media. So very important, I think, if you're going to express opinions that seem controversial or statements that seem controversial online, I would kind of just take a look at your profile, make sure that your employer is not listed on, for instance, your Facebook profile, for instance, sales representative at ABC Co. You could just write sales representative, for instance. Also, another thing to keep in mind is if you're someone who the public might associate with the company, then you have to be extra careful. So if, for instance, you're a spokesperson, right, for the company, you have to be extra careful for what you say online. So a spokesperson, for instance, imagine a news anchor would have to be extra careful of what they say online, because anything they say, it might be assumed that that's also the position of the television company that they work for. All right. So if you have a public facing role in any way, you have to be extra careful of how you behave online, or off any off-duty conduct. You have a heightened burden to make sure that your off-duty conduct does not cause embarrassment or reputational loss to your employer. Conversely, if you're someone that's just toiling away in the background and you don't interact with the public at all or anything like that, no one would think that your views represent the views of the company. You don't have the employer's name on your social media profile, then your off-duty conduct probably wouldn't have all that much impact on your employer's ability to terminate you, except if it's creating maybe tension with your colleagues, potentially. So all this to say, basically kind of depends, but if you are someone who's public facing, then you should be watching out for how, what you say and do might be perceived by the public and how that might kind of reflect on your employer. And generally, as a rule of thumb, you shouldn't have your employer's name in your description online, like on LinkedIn or Facebook or Twitter or anything like that, X or anything like that. That would be my thoughts on that. If this is something that's actually happening to you, Tina, maybe give me a bit more details on those questions. Are you in a public-facing role? Who's alleging that your off-duty conduct is problematic? How did they find out? that you work for your employer, things like that. And maybe I can give you a more precise answer, but as a general rule, keep those two things in mind. Is your employer easily identifiable from your online presence? And are you in a public-facing role? We have another question coming in from Sonia from YouTube. Sonia is asking, can an employer put you on disability leave if they claim your condition is preventing you from performing the duties of your job? I've been here for 3 years, have some issues with my mobility, and it hasn't been a problem until recently. So, Sonia, every job has certain basic fundamental duties, all right? And then every job has some other duties that are kind of not fundamental, all right? So you have to be able to do those fundamental duties of your job with or without accommodation. And if you can't do a fundamental duty of your job even with an accommodation, then your employer can't say, well, listen, we can't continue to employ you. You have to go on disability leave until you're able to do all the fundamental conditions of your job, all the fundamental duties of your job, even if that requires an accommodation, okay? So if you've been able to basically do your job for the last 3 years, but have required some accommodations or stuff like that, I don't think your employer has a strong leg to stand on to say, well, all of a sudden, no, we can't accommodate you anymore. It's causing us undue hardship or what have you. If you've been able to do it in the past before, with or without accommodation, it hasn't been a problem. So it sounds to me, just from what you've said, that you might have a claim here that you've been constructively dismissed because they're refusing to employ you, and you might have been the victim of disability discrimination under human rights legislation because they're forcing you to take a leave rather than accommodate you. I'd have to have the whole details, but it sounds to me if you're asking this question, that might be what's happening. So reach out to us. We're at employmentlawyer.ca. Provide us a little bit more background there. Before an employer can say, no, you have to go on leave, we can only take you back if you're 100%. That's not true. An employer has an obligation to accommodate you, all right? And it's very rare that an employer can say, you have to be 100% or nothing, or else you don't come back at all. First, they have to see, can you be accommodated, in your position. So reach out to us, Sonia. We're at employmentlawyer.ca. We have another question coming in from Demonic Jedi. I've been working for a company for several months and signed no contract. Would I be entitled to severance if I were let go? So generally, Demonic Jedi, that yes. So any employee who's terminated in Canada is entitled to termination pay, severance pay, and a severance package if they're terminated, whether or not you sign an employment contract. A lot of people come to me and say, well, listen, my employer is refusing to present me with an employment contract. I generally tell them, that's great. I wouldn't push for an employment contract. In fact, what employers do when they give their employees employment contracts is put in language in there to limit how much severance you're owed if you're terminated. If there is no contract, then you're entitled to your full severance. And if you're wanting to have an idea of how much your full severance might be, we have a severance pay calculator available on our website. Very easy, free of charge to find out how much severance you might be owed. Just visit that website, pocketemploymentlawyer.ca, and we'll give you an estimate of how much severance you might be owed. But if you hound your employer for an employment contract and they go see their lawyer and say, my employee is hounding me for a contract, can you draw something up? That lawyer is going to draw up something that's going to limit your rights as much as is contractually allowed, okay? So having an employment contract, you might think it's important to you. It's usually not to your benefit. Now, people will tell me, well, I have some things that I would like to have in writing. I would like to know what my duties are. I would like to make sure that my shift is not going to change, things like that, right? You can get that without getting an employment contract, right? You can ask your employer, can I get a job description with my duties, right? And an employer might have that and might send it to you. you might think it's important to have your schedule locked in. So you can just send an email to your employer saying, listen, I understand my schedule is Monday to Friday, 9 to 5, and then that won't change. Is that correct? Right? And if your employer responds to you and says, yes, you're absolutely right, without it being an employment contract the way you conceptualize it, which is with a lot of legalese and drafted by lawyers with clauses and subclauses, in the eyes of the law, that email chain is a contract. All right, that email chain is a contract of the employer guaranteeing that they won't change your employment, your schedule, your shifts, without your consent. Okay. So contracts do not necessarily have to have a whole lot of formality to them for them to be binding. All right. Generally, you just want to have them in writing because it's a lot easier to prove that a contract exists and what the terms are if it's in writing. But you don't necessarily have to have all that legalese. An email chain can definitely amount to a contract. Okay. Even a text message chain can amount to a contract. An oral contract is a thing, right? But a lot of employees run into trouble when they try to enforce an oral contract because they can't prove what the terms of the contract is, and the other side is denying that the terms are what the employee is saying. All this to say, you have the right to severance even without an employment contract. You don't need a contract saying that you're entitled to severance. So don't pursue that. But if other things are important to you, such as your job duties or your schedule or things like that, just get that in writing, in an email chain is sufficient. All right, we have one last question coming in from Joan. Joan is adding. Joan is the one whose job was rescinded due to some issue with the working visa. To add context, there was a question on the application whether I need a visa sponsorship. I answered no in good faith because I was authorized to work here. When I submitted my work permit, that's when they decided to rescind the offer, stating they thought I was a permanent resident based on my answer. Okay, if the truth is that you don't need visa sponsorship, Joan, then not only do you have a claim for negligent misrepresentation, severance potentially, but you might also have been the victim of discrimination under employment, under human rights laws. So basically, resident status amounts to a protected ground through place of origin protections under human rights legislation. So no one can be discriminated based on their place of origin. And that's been extended to people who have immigration status in Canada where they can legally work, but the employer wants someone who's a permanent resident or a citizen or who has Canadian experience and things like that. That amounts to discrimination. So that could be another area to explore if you call us to talk about what your options are. It could be that you've been the victim of discrimination based on your place of origin under human rights laws in Canada. Well, I want to thank you all for your great questions today. We had some very interesting topics of discussion. I hope that's been helpful to you. Once again, my name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin and the employment practice leader for Western Canada. If I haven't gone around to your question, please note that we have another show tomorrow at 1 p.m. Eastern with my colleague Sefton Liebrandt. He'll be answering all your employment law questions. If any questions I wasn't able to answer to you today, save them for tomorrow. He'll be doing the show for another half hour to answer all your questions. So thank you everyone for tuning in, and I will see you next time.